The trial of 8 VIP presidential protection officers who were filmed assaulting motorists on the N1 highway in Johannesburg last year. That trial has kicked off in Randburg Magistrates Court. The officers, who were part of Deputy President Paul Mashatile's security detail, have pleaded not guilty to the charges. The magistrate today, Abdul Khan, ordering that the media cannot divulge the witness testimony until the end of the trial. Let's get reaction now from Media Monitoring Africa's William Bird. William, good evening to you and thank you for your time. The decision here by the magistrate to bar news reporters from reporting on the proceedings of this trial. Can the judicial officer issue such an instruction without really giving an explanation?
Hi, good evening. I mean, an explanation is always preferable, but I suspect that what the magistrate was doing was going and saying, well, we know that there's some deep concerns have been expressed for their safety. I think we recall some stories a few months ago about witnesses fearing for their lives. And the magistrate decided, well, okay, because of that, we're going to not allow this. Now, I think that while that may be understandable to say, for example, you may not mention the name of any of the witnesses and you may not identify any of the witnesses. This is not an unusual, that would not be something unusual. For example, when we report on children in courts, you're not allowed to name or identify them. But I think where it would appear that the judge has erred is in respect of saying that they may not reveal any details of the testimony. We know that they weren't allowed to live stream the case or that they weren't allowed to film or even record the audio. So this is quite a restrictive approach to take, and perhaps while understandable in protecting the witnesses, it means that one of the issues where we really need more access to information to understand, we're now going to be getting a lot less.
Yeah.
So I would hope that some of the media houses are going to challenge this.
So two things stand out for me, William. One is that the judicial officer concerned, Mr. Abdul Khan, is new to this case. But second of all, the accused have long appeared on this particular trial, and as per the court procedures, you can report on the person's identity once they have appeared. Does that not confuse the media as a whole on the rules around court reporting then?
So in general, court reporting, the media can name an accused, for example, and indeed usually witnesses. There have to be particular circumstances where, as are present in this case, where the witnesses fear for their lives and their names are redacted, for example. And sometimes that happens at the court paper stages. So you may get the lawyers submitting their papers and they redact the names of the people involved in that particular instance. So here you're dealing with witnesses, and I'm sure, you know, there are legitimate sensitivities that would have been argued by the legal representatives of the witnesses to say, look, we don't want to take any chances. We can't, you know, our clients are very, are fearing for their lives. They're feeling high levels of intimidation. So I think that, you know, those are legitimate concerns. And what the judge should have done was said, okay, well, let's balance that against, you know, access to information, against open justice, the principles of allowing and ensuring that people can see this. There's a lot of interest and a lot of legitimate public interest in this particular case. And it appears that the judge has erred on the side of excessive caution in denying the media, you know, even the ability to report on the testimony. So, you know, fair enough. If he said no cameras because of the circumstance, he can do that. But then he should have said, well, you can report on the testimony, but make damn sure that you don't identify or reveal any details that may identify any of these witnesses, because if you do, you'll be in contempt, et cetera, et cetera. So there are avenues open to the judge, but it just looks like in this instance, he's made a call that I think is unfairly restrictive on media freedom.
Yeah, it's almost a blanket ban. It's understandable, William, as you're explaining it, that the sensitivities here are around the safety of witnesses. However, if the judicial officer's instructions stand, how will it affect the public's following of the case? Because I guess that's who the media is responsible to at the end of the day.
Well, exactly. People may legitimately, who don't know this ruling, unless the media put it in at the bottom of every story, are going to go and say, well, how come you're only telling the story of the accused and we're only hearing their version and we're hearing the version of the victims? But what about the witnesses? Why are you not telling us anything about that? And the media will say, well, because we're not allowed to, because it says, as I understand it, the order says that the media may not report any of their testimony until the trial has been concluded. And that really means that it's incredibly difficult to then give a valid or at least a reasonable picture of what's going on. And that really does fly in the face of what our courts have been doing over the last few years, which is allowing media greater access, allowing them to go in and cover it. So we know even in some of the more high-profile cases, for example, in the Oscar Pistorius murder trial, we saw there witnesses who said, I don't want my name in the paper, in any of the media, I don't want to be identified. And the court said, okay, fair and fine, because of these reasons, you've made a case, we'll grant you your request. And then they said to the media, you may not do this, or you have to distort the audio. Now, so there are mechanisms that you can use to make sure that that person's testimony could still be heard, but that you don't then prejudice other people's access to justice and to hearing it. Because again, if I choose as a member of the public to go and sit in that court, I'm perfectly entitled to do so, right? It's an open court. So it doesn't then prevent me from going and then putting that on social media, unless, of course, the judge finds out about it, and then I'll be in contempt of court, because that's where it starts to apply. So it really is a difficult thing, because you want media to be there, you want them to report responsibly, and the judge could have put down some quite harsh things. He could have said, because of these risks, I really want to stress to the media, please do not, cross this, be in contempt. If you name or identify or reveal details that may identify these witnesses, you'll be in big trouble. So they could have done it without then saying, but you can't report on any of the testimony until after the trial. So that just means we're going to get most likely quite a lopsided picture. So we hope that, as I've said, some of the media houses challenge this.
William Bird, thank you very much for your time and analysis of the goings-on in this trial. He is from Media Monitoring Africa.